Today we're going to talk about disputing a mechanic's lien in New York. And there's a few things you can do to respond to a mechanic's lien once you receive it and you want to challenge it and dispute it in some way. So the first thing we're going to look at, the easiest way, the fastest way to challenge the lien is just to file a discharge bond. That's under Section 19 of the lien law. And it basically says you can file a lien at any point in time after the lien has been filed. And by statute, the bond must be for 110% of the lien. And it depends on the county that you're in. Some counties will require you to purchase an index number when you file that bond. Some counties don't. So it's a county by county analysis. But every county, the bond has to be 110% of the face value of the lien. And as long as the bond complies with the lien law and is accepted by the county clerk, the lien is discharged on the spot. That doesn't mean that it's defeated, it's not vacated, it doesn't no longer exist. It's just discharged from the property itself, and essentially the bond then attaches to the lien. And if the lien holder wants to enforce their lien, they're going to enforce it against the bond. So the discharge bond really only removes the lien from the property. It doesn't defeat the lien itself. If you want to attack the lien itself, the first thing you can look at is, do I have a challenge to the lien on its face? And if you do, you can file a Section 19 petition to challenge that lien. A petition is a special proceeding that you're going to file in Supreme Court, and you're going to ask a judge to review the lien on its face, and for whatever reason you may argue, determine whether that lien is valid and complies with the lien law, and if it does not, to discharge it for that reason. On a Section 19 facial challenge, you cannot go beyond the face of the lien. So if your dispute is they didn't do the work, or they did a poor quality of work, or they're not owed the amount of money set forth in the lien, those are not Section 19 challenges. You cannot raise those in a Section 19 petition. You have to challenge what is in the face of the lien. The court must generally assume that the facts in the lien are correct on a Section 19 petition, and the judge's sole role is going to be to determine, do the items set forth in the lien satisfy the lien law? If they do, the lien is good on its face and you're not going to discharge it. If they do not, the judge is going to look at, was there substantial compliance with the lien law? So some insignificant or minor deviations or errors can be forgiven by the judge, as long as there's substantial compliance with the lien law. But if the judge determines that there is not substantial compliance with the lien law, the judge can discharge that lien under Section 19. Now, a Section 19 discharge is not a discharge on the merits. That means that that lien holder can go file another lien right after it's been discharged, provided that the lien holder still has time to do so. Section 19 petition does not extend their time to file a lien. So if that petition is brought within the time frame to file a lien, they can file a new lien correcting whatever facial defect there was. If there's no time left to file the lien and it's discharged under Section 19, the lien holder is out of luck and there are no more lien rights. Now, if you do want to challenge that the money is owed, whether it's just because the amount is wrong or because you believe the work is defective, that can only be done in a foreclosure action. The lien holder has 1 year to bring a foreclosure action, and if they don't do so, the lien is going to expire. They can extend the lien. In a commercial property, they can extend it up to twice just by filing an extension of lien. On a residential property, they've got to get a court order to extend the lien. But in either instance, they can extend the lien. A foreclosure action is going to extend the lien as long as a lis pendens is filed for the life of the lien. So once a foreclosure action is brought, you can challenge that that money is not due, or that work was not done correctly, so that money is not due. It may be, in fact, the lien holder is owed nothing and owes the property owner back. But you have to get the lien holder to bring a foreclosure action in order to raise that challenge. So what you do is you file a demand under Section 59 of the lien law. That essentially is going to start that clock early. Although the lien holder has a 1 year period to enforce their lien or extend it, Section 59 is going to give them a 30-day window. Once they're served with the Section 59 demand, they're on a 30-day clock to enforce the lien. And if they don't, they have to show cause to a judge why the lien should not be discharged. I didn't want to file the lien. I didn't want to enforce the lien. I don't have the money. I don't have the time. Those are not necessarily going to be accepted reasons to not file within that 30-day window. So it has to be a valid reason why it should not be discharged for failure to foreclose within the 30 days. Procedurally, what happens is you serve the Section 59 demand. You wait the 30 days. If no foreclosure action has been commenced, you're then going to commence a special proceeding. You're going to file a petition with the court saying that you've served the Section 59 demand on the lien holder. They've not commenced the foreclosure action within the requisite time, and the lien should be discharged. The judge is probably going to order either a return date or even an argument or a hearing to determine whether that's true. And if it is, in most instances, if the demand was properly served, no foreclosure action was commenced, and no good cause is shown, the judge is going to discharge that lien for failure to enforce it within the 30 days. So you're not actually even going to get to, is the money owed or was the work defective? It's actually discharged for failure to enforce within that period. If the foreclosure action is commenced, now in the foreclosure action, you can raise your defenses that the money is not actually owed, or the work was defective, or whatever other reasons you want to attack the lien that go beyond the face of the lien. Now, if you don't necessarily want to go to that length to potentially get yourself involved in litigation right away, which could be not only very time consuming, but very expensive to defend the foreclosure action, you can also try to serve a demand pursuant to lien law section 38. Section 38 of the lien law is also good if you don't necessarily know what's included in the lien. If you want to find out more, what does this contractor or this supplier think they're owed that makes up the amount of the lien. So you serve a Section 38 demand, you serve it by certified mail, and the liener is going to respond to you, and they have to itemize exactly how they calculated the amount of their lien. There are a few little nuances in it. If a contract was completed, if there was a contract for the work and it was completed, the liener doesn't have to explain how they came up with the contract price. They can say, I had a contract for $100. I completed the contract. You owe me $100. They don't have to break that down. But if you don't have a contract for an amount and the work was not completed, then you have to itemize the lien. You have to provide all of the breakdowns by line item. So this is the labor that was used. This was the rate of labor that was charged. This is how much time was spent. Here's the line item of materials. Here's how much those materials cost. If that is not actually provided by the lien, they don't provide a proper itemized statement, then Section 38 allows you to, again, file another kind of special proceeding. And that's to force the liener to provide you with a proper itemized statement. And once the judge orders the lien holder to provide that itemized statement, if they don't do so after being ordered to do so, Section 38 will then allow the judge to discharge the lien for that reason. So the Section 38 is really a two-step process to get the lien discharged. It's first serve the demand, and then if there's not a sufficient response, get a court order, and then if there's still not a sufficient response, you can ask the judge to discharge the lien for that reason. So these are just some of the ways you can respond to an attack, a mechanics lien in New York. You can file your bond if you just want to get rid of it. You can file your Section 19 petition to challenge the face of the lien. You can file your Section 59 demand to dispute the amount of the lien is due and force a foreclosure action, or you can serve a Section 38 demand and force the lienor to itemize that lien, explain what is due, and if they fail to do so, you can get it discharged for that reason. We have a lot more information about ways to challenge lien on the website. You can always contact us in the office by email or by phone, and we have some more videos as well explaining various ways you can challenge lien in